Hello, my name is Tim McCurdy and I am a guardianship attorney practicing in St. Louis, Missouri. Today we're going to be talking about when someone can go to court to seek an emergency guardianship. A guardianship is when the court appoints someone to manage the affairs of another person who has been found to be incapacitated. Incapacitated means that the individual is unable to make decisions about where they're going to live or who they're going to see for the doctor and manage their own affairs. And when the court decides that a person's incapacitated, they're going to appoint a guardian to make those decisions for them. But a guardianship process can take anywhere from 2 to 6 months after the petition is filed, after all the paperwork is filed, for someone to be appointed by the court. And the reason for that is there are a lot of procedural steps and safeguards in place before the court is going to appoint someone as a guardian. If you think about it, it's because this is one of the most significant things that a court can do. The court is finding that an individual no longer has their personal liberties, that that person can no longer make decisions for him or herself. So before the court is going to do that, the court is going to be certain that this is appropriate. They're also going to make sure that anyone who may have an interest in the proceedings receives notice so that they're aware of it. But what happens when you don't have 2 to 6 months for someone to be appointed? What happens when there is some sort of emergency where the person's life could be at risk if they had to wait very long? In that circumstance, the court has the authority to appoint what is called an emergency guardian ad litem. And this is going to be, again, in an emergency situation. This is when the person is at immediate risk and we simply can't wait for the normal course and practice. And again, that needs to be some type of a serious risk of physical harm, and they call it a substantial risk, and it has to be imminent. It could also be if there is a risk to the person's property, a substantial risk of irreparable damage to a person's property. So this could be the example of someone, due to their incapacity, their disability, they're being taken advantage of. They've been defrauded into, someone saying, hey, send me all your money, and people are going into court to stop that. So again, this is going to be only when that person cannot meet the essential human needs. So it has to be an emergency situation. There has to be a serious risk of physical injury or substantial property damage, and that's going to justify skipping over some of the procedural safeguards that are normally in place for a guardianship, to where the person can't protect their property, and this has to be done. In that situation, the court is going to appoint an emergency guardian ad litem. So this is someone who's going to step in and be able to manage the affairs of the person and quickly so that they can prevent these things from happening. To do this, you would file a petition for the emergency guardianship or conservatorship. Conservatorship is just the finances, where the guardianship is over the person. So it may be that you have both. It could be guardian and conservator, or just guardian or just conservator, depending on the circumstances. And in that moment, the court is going to appoint an attorney for that person. So there is going to at least be that safeguard that says, okay, before we appoint an emergency guardian ad litem, we're going to appoint an attorney who's going to meet with the person. They're going to report back to the court. They're going to have some representation at the proceeding, so that at least there's that protection. They also have to serve the guardianship paperwork, the petition, and various other filings on the person who is alleged to be incapacitated, and they have to give notice similar to a guardianship petition, but you're doing this all in a very short period of time to interested persons. That could be a spouse, could be parents, children if they're over 18. The proposed guardian receives notice if there's a fiduciary. The person with custody, where the person is living, maybe if they're in a facility, something like that, they have to be given notice. And the big difference is that the court is required to hold a hearing within 5 business days. So this is something that, for the court system, that's moving very quickly to decide if an emergency guardian ad litem appointment is necessary. Now they're going to allow the appointment of the emergency guardian ad litem, but it's going to be limited. So if a guardian ad litem is appointed, it cannot be for longer than 90 days. And there's a specified purpose. So it's going to say this is what you're in charge of as the guardian ad litem, deciding where the person's going to stay, talking about what you're going to do with their finances. This is, a specified period of time, and during that time, this is what you're allowed to do to protect the person. Now, the appointment can be extended and 90 days at a time. So if the guardian ad litem came back and reported and said, well, this is the situation, we need more time to get everything sorted out, the court has the power to do that as long as there's a hearing to determine that. And also the expectation is that during this time, during this initial 90-day period, that there's going to be a petition for a regular guardianship filed. That this is something that's done on an emergency basis, but then going forward, there's going to be a petition to have someone appointed as a full guardian or conservator for the person. And if there's delay, if for some reason that hasn't happened during this time, the court, if there's a motion, could dismiss the appointment of the guardian ad litem by saying, well, the emergency is no longer in place, no one has petitioned to be guardian, so we don't need this any longer. Now, it is cautioned in the statute, though, that this is not a substitute for what's called a civil commitment for mental health. And you may be familiar with that as a 96-hour hold where someone can be admitted to a psychiatric facility to be evaluated. That's not what we're talking about here. This is specifically for the emergency guardian ad litem. I hope you found this information to be helpful. Keep in mind that this is general information and should not be considered legal advice, and that if you are dealing with issues that relate to guardianship, or if you think you may have a fact pattern that would fit with an emergency guardian ad litem, please feel free to call me and I'd be happy to discuss your issue with you. Thank you.